Welcome, guys. This is day 5 of the 30-day wholesaling challenge. My name is Rick Gim, and today we're talking all about contracts. And honestly, if you have never filled out a wholesaling contract, you've never done an assignment of contract, and you want to check it out, this is the video for you today. I'm going to walk you through on how to do the purchase and sales agreement, which is also known as a PSA, and then we're going to follow up and show you how you can sell your contract. As wholesalers, we sell the contract. We don't sell the property. We're not beautified realtors. And I'm going to show you how to do an assignment of contract. Now, most gurus are going to hide this in their courses. They're going to make it very behind the scenes. You got to pay big dollars. I really don't believe in that. Not sure why it's done. So let's just get right into it. I want to walk you through. And the best part is this is all recorded. You can go into freewholesaling.com. We update this every year. I don't regurgitate this stuff. I walk you through it. Why? Because it's important. You have to understand the mechanics of a contract. So I'm going to jump into it. Now, before I do it, I have to give some disclosures. Number one, I am not your lawyer. I am not a licensed lawyer. I do not practice law. I have no intentions of doing it. And I'm giving you my opinion on how to fill out these contracts. I always tell everyone to seek out the advice of a professional real estate lawyer in your local market. If you're doing it virtual, make sure your contracts meet the requirements for your state. Guys, stop taking everyone's word for it. Go meet with someone that says it's okay. I would start with a title company. And if you need clarification with a lawyer, but whenever in doubt, always seek out legal professional counsel. That's not me. I'm not going to give legal and I'm not going to give accounting advice on this. Now, with that being said, I'm here to tell you, a lot of lawyers will tell you, oh, this contract doesn't work. It's ridiculous. I've been doing this business 21 years. I have over 3,000 solidified contracts that I've used on this particular model. And the one I'm going to teach you today are the simplest contracts because I don't believe in complicating wholesaling. So don't be surprised if a lawyer goes, I don't know about this contract and I'm not sure. It's like the lawyer's job to do it. So I'm just telling you, if I've done over 3,000 deals, mostly on this type of contract, they must have worked for 3,000 other instances for lawyers. So don't let that stop you up. Honestly, consult with your title company, also a real estate lawyer, and let's get into it. And what I'm going to do is do a screen share. And I figure the easiest way is just to write this out live with you while I do it. And then what we'll do, if you have a question, do me a favor, put them in the comments and let's answer them. And if I have enough time at the end, we'll answer some questions with some one-on-ones. So stay awake. I have ADHD and I'm about to walk through like how to do a contract, but this is important. Here's the really cool part. Before we get to the contract, so we've done the legal disclaimer. The next part is, this is the part where you're just reaffirming your verbal agreement. At no point should a physical contract, any type of contract, be a negotiating tool. It will ruin any type of relationship you have with your seller. So I can't stress this enough. At this point, you've already agreed on terms and price. At this point, we're just going to write the contract. My suggestion is keep the contract in your car, keep it separate on your bike, wherever it is, and then ask your seller permission to go ahead and grab a contract and we'll fill it out together. And now I'm going to walk you through just like you're filling out a contract. I am going to explain it to you at a wholesaler's level, and then you can easily translate this to do it with your seller. And I'm going to give you some tips on how you can work with your seller. So guys, stay awake. I know we just passed July 4th. It's a good time, but like we are day 5 of the challenge. We have got to learn how to do these contracts. So let me switch my screen over and I'll put myself down here in the corner. If I get in the way, I'll move it up. So the first one is you're going to put on the date. So we are on the 5th. Let me pick a pen out here. We'll do black. Okay. The 5th of July. And we're in 2024, guys. Awesome year. Now, this is the agreement between you and your motivated seller. So you are going to be the buyer and your seller is going to be the seller. So we'll just call the seller Jane Smith. And you're the buyer is, let's just go with, why not? Fortnite LLC. And that's the buyer. Very simple at this point. Now, guys, I literally do this in front of the seller because it puts them at ease. It's like the worst thing you can do, in my opinion, is carry in like a briefcase or a thick paperwork and like intimidate your seller. And the second worst thing you do is have a completely filled out contract. Doesn't mean you can't be familiar with it, but they feel like you're just a common person and they can relate to you. If you come in with like very fancy, sophisticated contracts, you're going to freak them out. So the next thing is we're going to do the street address. So 123 USA Street, city and state, pretty straightforward. We'll just say Stuart, Florida, 34997. And then the legal description. Where do you get the legal description? Honestly, you really want to get that from the official records. And if you can copy and paste it, but if you're writing it down, you can put it in here. Now, most of the descriptions in the property appraisers are very short snippets of the actual legal agreements that you can only find on the deed. Sometimes you can find it in your county's official records. Some counties make it very, very difficult. I just did a property. I think it was South Carolina. It was hard to find, and we actually had to get it off the deed. Now, a little trick you can do is you can use the parcel ID number, which I love to use, and it's usually like I think it's like a 9-digit code. That works really specific, and it's, well, listen, the more you put on here, the better. But I'm just telling you, make sure you get the address and the legal description on there. And if it's a really long form, I would put the parcel ID number. If you don't know where to find that, you can always find that on your property appraiser site or your local tax county collector. I know this is exciting, but you got to stay awake. So somebody like say, Rick, I get it. Get me through these contracts. So that is the first part of what we're doing here. So these are only 2 pages, guys. And it is done by design because most of the sellers we deal with, they just want to get the property sold and they want all the games eliminated. So they've agreed on a price. So we're going to make it as simple as possible. A contract can be as long as 30 pages in real estate for a single family home, which I find outrageous. And most people are very happy to do these 2-page contracts. So we get down to the next one where you're going to see total deposit. I'm going to be honest with you. You guys freak out at this one, and you've got to stop putting so much emphasis on the deposit. So what I want you to do is focus right here on total price. So for instance, if we have agreed at $150,000 purchase price from the seller, right in there, $150,000 first. Why? It puts your sellers at ease and they know what you're paying for the property. Why do I want to do this first? It's important because if you start with the deposit, a lot of sellers get that confused. They're like, why would you leave $100 deposit if you're going to pay me $150,000? If you put $150,000 first, you draw attention to what the total price you're giving them to solve their problem. The deposit, guys, quite honestly, is a mechanical function of doing a wholesale deal. But like, let's face it, we're trying to get out with a minimal deposit. So I don't want to draw attention to it. It doesn't mean my intentions are not to sell. So ideally, I'm going to put $100 deposit, and then it's just, you have the balance of it of $149,900 to close. Now, what do I do if the seller says $100? Are you nuts? Go, listen, I'm paying you $150,000 for the house. We can sit here and go back and forth on the deposit. It's just the deposit. That money goes into what we call EMD, which is earnest money deposit, which is going to be towards your title company. At this point, guys, hopefully you've seen our title video and you want to have a relationship with your title company. Whatever amount you put in deposit, 100, 500, 1,000, whatever it is, you need to get a earnest money deposit letter. That shows that you put a deposit down and you have a valid contract. So if we start with total price first right here, and then we minus off the deposit. I usually don't get as much of a hassle, but in the beginning, when I started out on deposit, they confused it with purchase price, and you can actually kill your deal before it even gets started. So don't freak your sellers out. It's just a simple math problem. Don't forget on how that works. So if you have a question, put it in it. I'll try to answer them as I go along. Remember, guys, I am not a lawyer. I'm not going to get into the technicals of everything that works, but your deposit is your EMD, and it's important, and you understand. Now, ideally, I would love for all of you to leave $100. $100 is being shamed lately. I recommend probably doing close to 500. It gets the least amount of resistance, but you can start at 100 and go up to 500. Because the problem is, where do you stop? Do you go to 1,000? You go to 3,000, 5,000? I've seen some sellers as of lately even ask for the entire amount for the deposit. It just kind of defeats the entire purpose of how we do due diligence in real estate. So if you start too high, you get stuck. So my recommendation is start at 100, try to stop at 500. But guys, let me give you a disclosure. I've been doing wholesaling 21 years. If you have a really good deal, like they're giving you an amazing deal, and their only requirement is for you to leave $1,000 or $2,000 deposit, go find the money somewhere. That money's secure. It is a great deal. It is just a deposit. Worst case scenario, not worst case scenario, best case scenario, reach out to me and Zach and we'll help you out. I'd rather you partner than lose the deal. I see so many people lose great wholesale deals just over the deposit, and it's just a simple amount. It's a simple factor of figuring out the best resources to get it done. I get it. I was in a time of my life I didn't have the resources for this, so I would bring in cash partners. You have more options in 2024 than you've ever have, and do not ever forget it. So if you're getting something 50 cents on the dollar and like it doesn't need a lot of work, but they require a $5,000 deposit, bend over backwards, get a hold of me and Zach, and we'll put the deal together for you. Like, don't lose out. The deposit is not the deal. And so many people get killed and held up by the deposit. Realtors are really flooding the market, trying to tell everyone they have to leave a huge deposit. Honestly, you could technically get away with $10, but those days are over. 100 to 500 bucks is where you want to be. And remember, once you go past that, where do you stop? That's why I want you to start with the total price on the contract. So let's keep moving on here. The next one, by the way, I see your comment on the subject to contract. They're actually easier because you just, most real estate contracts, it's built into it, but that's going to be another video. So we are going to move on to the next section, and we're going to go to paragraph number 2 here. So the word prorations is just a fancy word on how they're going to divide up taxes if there's a rent deposit, a security deposit, and a rent. So a proration goes like this. If I bought the house in June, 12 months in a year, then basically the seller would be required, because the taxes in most states are due somewhere towards the end of the year. So if a tax bill comes up and say it's $1,000, say it's $1,200, that means $100 a month. So somebody owes $600 and somebody has to receive a $600 credit. Now, here's the good news. You don't need to figure this out. Your title company will handle this all for you. But if the property tax was $1,200, if you bought the property mid-June, you, the buyer, would get a credit for $600 and the seller would get a debit for $600. Don't worry, you're not paying for it because you're going to pass it on to your end buyer anyways. But these are what called prorations, where they split up the bill and they can do it on a monthly or even a daily balance. Honestly, we don't get mixed up too much in these. Most of the deals I take over, there's very little deposits and stuff like that. But if you do it straight up, this would work just like a traditional real estate contract, and there would be prorations unless you state otherwise. My recommendation is don't change this. Leave it exactly the way it is, and I'll show you how to progress and get what you want out of these contracts. So, awesome. Okay, so you go down to paragraph number 3, closing date and transfer of title. So I want to show you on the important thing is on number 3. We're going to spend a little time on this one because this is where a lot of your questions get answered. So think about all the questions you guys have asked me over the last 4 years with freewholesaling.com. So people always say all the time, let me try to see if I can find the highlighter here. What do I do if I buy a property and there's a lien on it and the seller doesn't know about it and he can't clear it? Am I stuck with that lien when I buy it? No. So you have to see, it says seller agrees to transfer marketable title free and clear of all encumbrances except for the ones listed, except for the ones listed, which is going to be the mortgage, the property tax, stuff like that. So if you get a property where you just can't clear the title, even the day before the closing, you're not obligated to close. The key is they have to transfer marketable title free and clear of encumbrances. Now, everyone says, Rick, well, how the hell am I supposed to know that? It's not your job. Your job as a wholesaler is to find motivated sellers and market to them and connect with them and build relationships and a rapport. That is how you make money in this business. Trying to figure out if you have marketable free and clear title, you'll lose your mind. As soon as I get under contract, I get any information from the seller about any issues we might have with the house, and I give it to the title company to run a background check to see what's going on with the title and see what they owe against it. Do I get surprises? Hell yes, all the time. Actually, I expect them. How do I fight off surprises? The sooner you deliver that contract to your title company, the sooner you can solve the problem. I hear so many of you out there like, well, I'm going to wait to pull title because I'm not sure. No. Always pull title first. Period, guys. I'm just telling you, it's like some of these things can tie you up for months. I've seen it even years. So get out in front of it. A lot of problems can be fixed within 30 days. So don't wait the week before you're closing to give it to your title company to see if you have any problems. So if you have that problem, it will work. And you've got to understand that. The next one I want you to understand, I'm going to change colors here. Everyone's like, well, do I put a hard closing date and how do I do this? Simple. We use shall close on or before, and then you have these dates right here. Why do I do that? Guys, simple. On or before gives you the ability to close it up to that last day or any day before, once you give your seller ample time to understand that. Why is that important? Well, guys, here's the reality of it. A lot of people play games between the closing date and their inspection date, or they try to coincide them. So if I have a seller that goes, well, I want to do the deal with you, Rick, but I'm not sure exactly when I can move out. Is that going to work for you? Now, what are my options? What am I going to come back and redo a contract? You're absolutely nuts to do that. You need to go in and get an agreement. They like you. They like the terms of your deal. They want to get it done. They just need some flexibility. Well, guess what? I simply say to the seller, that's not a problem. Since I'm not moving into the house, I want to work with you. What do you think is a reasonable amount of time for you to get the house packed up and get onto your new home in Texas? She goes, honestly, I can probably get it done in like 45 days. Okay, so I say 2 months, right? Now, a lot of you are going to go out there and go, okay, I'm going to put the closing date for 2 months from now. No. Guys, listen, unless you want to chase people around to renew your contract, what I want to do is I'm going to give, in this situation, I'm going to set it for 90 days out. So we're in July 5th, so July to August, September, October. So that's going to be 10/5/24. You're like, Rick, you're crazy. Listen, on or before, that means you can close early. And you don't have to constantly keep reach out to your seller and trying to get the contract renewed. The reality is when contracts expire, people freak out. Even though they're still legally entitled, I'm not going to get into the legal definitions of it, but you're best off to give more of a gap because it makes your seller feel more comfortable. You can plan accordingly, and that also gives you time to market the property. So now, most closings, I'm going to be honest with you, are within 45 to 60 days. The fastest most people do them is 30 days unless you're an advanced investor like me and you can just take them down with your own cash quickly. I don't want you guys to do that. So the average person, I would put probably a 60-day close, even if I said 30, because stuff happens. Hurricanes come, people get sick, COVID strikes people, like crazy stuff. So build in some contingencies into that date so it's not so rigid. Because I'd rather you have a longer date, because when they're ready to move, they're going to move. There's nothing you're going to do to make them move faster. So most people got to pack their houses up, and you have to understand that. So that moves us on to the next part, which is paragraph 4, damage to the property. This basically gives you the ability to do a final walkthrough with your cash buyers that are going to buy your contract to make sure that property is in still the same condition that you originally looked at it in your contract. It's important to have these in your contract, because I have come back to properties and they're completely different. If they do that, you have the right to renegotiate the contract or actually get out of the contract without harm. So now we talk about harm. So once again, guys, I am not your lawyer, but I'm going to give you the truth here. Everyone says, Rick, what is my worst case scenario if I don't close on the deal? Now, this is not a permission slip for you to be a reckless wholesaler. And I'm going to do my best to explain this to you. We need to write contracts to help people out. Me and Zach do not teach you to go out there and just throw crap on the wall. You can't do it. And honestly, if you have a poor closing percentage, like you only close 50% of your deals and you're doing it in your local market, it means you have not learned wholesaling correct. If you want to learn how to do it correctly, go over to freezewholesaling.com. Not all deals are going to close. Nobody bats 100%. If they do, they're not real wholesalers, or they're like out of the business. The reality is some deals will fall apart because the title didn't clear, your seller didn't cooperate, your cash buyer didn't work out. It happens. It happens to me. It happens to Zach. It's going to happen to you. But if it happens all the time, if you're overpaying for property, stop overpaying for them. Go to freewholesaling.com. I'll show you how to actually do the business. But here's what happens. Your worst case scenario, if you go to paragraph number 5, if the buyer, that is you, that is us, the buyer, defaults under this contract, any and all monies deposited by buyer shall be retained by seller as full liquidated damages. End of story. So if you left a $100 deposit and both parties executed the contract, that is the most the seller can ask for in damages per the agreement. Now, it does not make you immune to any type of court proceedings. It does not protect you against fraud or anything like that. That's why I don't want you guys leaving $10,000 deposits, because you're not going to get it back. And that's the problem with it. So this is your worst case scenario. This is why we want newer wholesalers to use our contracts. I use this contract, and I've been doing this 21 years. Why? Because I'm looking for motivated sellers that need to sell their property now, and I want to help them out. They give me a great price. I give them speed and convenience, and we move fast. Everybody wins. That's how the game's played. I find realtors, gurus, they make these contracts so complicated. Guys, this contract alone, I didn't create it. Like I've used so many renditions of it and so many adjustments with lawyers. I would never enter into a wholesale contract without this, because I want to know what my worst case scenario is if it doesn't work out. And it's not going to be because I don't want to move forward with the deal. It just means because something's blocking the deal. Maybe a title issue, something like that. Maybe the seller backed out. But that's why we don't leave ginormous deposits, because we are selling the contract and we know it. So get the skill sets, but understand, guys, this is your worst case scenario right here. So if you leave $100 deposit, you're risking $100. And I know that's risky for some of you, but we all have to start somewhere. And I want you to understand it. The next one is number 6. Everyone's like, what the hell is this one, Rick? Successors and assignees. So terms and conditions contract shall bind successor, heirs, administrators, trustees, executors, and assignees of the respective parties. Basically what it's saying is, and I've tested this part of the contract out. It basically says if the seller dies and the property is taken over in a trust or a beneficiary is created, this contract's still enforceable. And I want a huge contract I want a huge, outcome in court. I used this contract. It took 6 months, but I wound up buying the house because I worked so hard with the gentleman, and then a trustee came out of nowhere, tried to wipe me out. I did hire a lawyer for full disclosure. I gave him the contract and he said, that's ironclad, section number 5. We got an immediate judgment by a judge and we moved forward with our deal. So the bottom line is this contract protects you, and even in the worst case scenario. Now, most contracts do, to be fair with it, but it's important that you understand how that works. So let's keep moving through this contract because we got a lot to get through here. So on the next one, let me change my... No, let's go back to that. Access. A lot of you guys get tripped up. Most contracts in wholesaling have some sort of marketable or access clause. Now, I try to write it as gently as possible without being an idiot. And this trips up a lot of your sellers, and I want you to understand this. So it says sellers agree that the buyers may advertise property and have access during reasonable hours to show the property to others. Now, this is the truth, guys. I like to give the truth. A lot of times you have to talk to your sellers. Sometimes the sellers don't even read this line. But you need to know and read your sellers. If you have an elderly person in there on oxygen that is very frail and they can't have people coming in there, you have to understand what you're buying. And you got to understand you can't parade 15 people through there. You maybe get one person in there and you're going to have to schedule it perfectly when she's out of the house. On the other hand, some people really enjoy the company and they actually like it. So whatever we put in writing, you need to use the human clause, your brain, and go, okay, these are reasonable people. This lady will let me show it to anybody, and this guy's not going to let anybody in. You have to know. Sometimes we only get one shot at selling our contracts. Sometimes these are deals you got to figure out how to take it down and get funding if it's a great deal to make it work. So understand when you're doing it. In the beginning, you have to understand that. So why do I want to put that? Because I am going to bring people through there. How do I explain it? I usually tell them they're my partners. I bring in contractors. I bring in some of my cash partners. It is the truth. But always know the temperament of your seller, because if you don't understand it, this is where you can create problems. Now, I've had maybe 10% of my sellers want to change this. They're like, well, no access on the weekend, and you have to be with them. Yep, that's fine. I'll go ahead and write that in there. Just work with them and talk to them. Don't use this as an intimidating thing. And then the next one is moving on is number 8. It's assignable. This contract is assignable by the buyer. Black and white. I don't hide it. It doesn't matter where you put it in the contract, but I've never had a motivated seller question my assignability. The only time it's come a problem in modern day is realtors like kind of push. You don't want to have an assignment contract. It's because they don't understand it and how it helps their sellers. So we have to have assignable contracts. This one is non-negotiable. If somebody tries to strike this out, you are going to probably have very limited options. And if you don't have funding, you don't have your own cash, you don't have a cash partner or a cash alliance, and you strike out the the assignability clause, you are going to be in trouble on it. So let's go over my favorite part. So now we're on number 9 on the inspection. And this is where, like, well, wait a minute, Rick. Which is more important, the closing date or the inspection? The closing date's what you agree with the seller. And it's usually based on their personal needs when they need to get out of there. And most sellers, honestly, it's very rarely they move out in less than 30 days, especially if it's homeowner occupied. Now, if it's a rental property, whole different ballgame. Understand that. Now, the inspection. If you guys want to put in the comments, if you had a dream scenario on a wholesale contract, what would you put in for the inspection? What would it? Would it be something that mirrored the actual closing date you put on the contract? Because you can't put in like a 6-month inspection period and have a 30-day closing, because that doesn't even make sense. I see that stuff all the time. I'm like, how the hell did you do that? That's amazing. So usually the inspection should be somewhere within that time frame of your closing date. So if someone's got an idea what you put onto it, because I put this recommendation out for, what is the ideal inspection? And that's perfect. 60 to 90 days is correct. Is that reality in 2024? Listen, if you don't ask, you don't get. And that's how I look at it. But typically, in a perfect world, I'm going to put 60 to 90 days. But keep in mind, we already have a 90-day close. So on this one, I would probably put 60 days. But guys, I'm going to be honest with you. Here's the reality of most wholesale deals we do in our market today. If you can get 60 days, that's amazing. 90 days, no brainer. Why? Because the more time you have an inspection, the more options you have to go. My recommendation is I would never go less than 30 days. Wait a minute. My handwriting's getting all marred up here. Let's try it again. Let me put this writing. Never less than 30 days. Like, well, Rick, I have somebody, they want to do it in 7 days. I go, well, how many wholesales you done? I've done 0. Well, do you have any cash buyers? Not really. How are you going to find a cash buyer in like 5 or 6 days? They do exist, but I'm telling you, you don't have the experience level for it, and you're going to get pinched. Now, if we read the rest of this, you understand. So within this inspection period, you can perform an inspection. Utility services may be provided by the seller. And so buyer shall be responsible for prompt payment for such inspections, meaning if you pay for an outside inspection period. And guys, I do not do outside inspectors. You're looking at foundation, roof, electrical, basic plumbing. Tired properties, motivated sellers, properties give you clues on where there's problems. It's not hard to figure out. But listen, if you're buying at a deep enough discount, you should be able to cover anything. If you don't understand how to do this, try to talk to a fellow contractor or someone who's very construction knowledge and form an arrangement with them. Take them to lunch, make them a business partner, pay them $100 per inspection, whatever you want to do. That's if you have absolutely no knowledge at all. But I'm not inspecting the drywall. I'm not expecting the finishes. I'm just making an overall assessment of the condition of the property. Now down here, if you look at here, in buyer's sole discretion that the condition of the property is not acceptable to the buyer may cancel this contract by delivering written notice of such election to seller prior to the expiration of the inspection period. If buyer timely cancels the contract, the deposit shall be immediately returned to the buyer. Therefore, the buyer and seller shall be released and all further obligations from this contract. So the question comes down is, I know you're like, Rick, can you change it to where we can send a text or an email? No. This is the legal acceptable. This is what holds up in the court, and that's why I don't do a change. Now, how do I work the inspection period? It's simple, guys. Be responsible. If I have a 30-day inspection and I've gone 3 weeks and every cash buyer told me my contract's overpriced, I thought I paid too much when I felt do it, I've taken the clues. You have 2 options. What are your 2 options? It's real simple. You ready? Renegotiate the contract or cancel the contract. Those are the only 2 moves you have. Now, if I have 30 days, please don't wait till the 29th day to do it. You should know within a week if this thing's going in the right direction or not. And so many of you guys, actually, I've seen so many good deals you put under contract, and then like you wait and you freak out and you didn't get your cash buyers list going, and you're trying to do it and you're like, I'm not getting the activity I want. It doesn't mean you have a bad deal. It just means you didn't take the time to build the cash buyers list, and you got to learn from it. So that is an opportunity to JV, especially with somebody in the comments here, in Flip with Rick Plus. You can go over to zachdiscord.com. I'm telling you guys, let's save good deals, but you need to understand how the inspection period works. So here's what I do. If I'm getting out of an inspection, if I'm getting out and I can't find a buyer, I'm going to send a piece of certified mail to the seller's house. Why? It covers my butt. I have it time-stamped and it's done. Nobody can ever dispute that. Now, can you send an email? I would still send an email. I would still send a text, and I would still make a phone call. Some of you aren't going to do that, and that doesn't make me happy. We've got to be good business people. So if you're going to get out, give them a timely manner to get out. It's their property. We owe it to them. But guys, don't, like, you hate when your sellers ghost you. Don't do the same thing back to them. It's not good business. Listen, I believe in karma. Things come back. If you got to take care of people for people to take care of you. And so let's help people out. If you're getting really bad feedback and it's nowhere in close, just dive in. And a lot of times when you reach out, they'll offer to renegotiate with you. Now, one of my strategies I use, if you guys overpaid for it and you bought some guru's course and they taught you how to buy properties on MLS and you overpaid for it, the easiest way is, where can I send over the cancellation? Why do I do that? Because if say you have it under contract 150 and nobody wants to pay you more than 100, it's going to be a hard negotiation. So my strategy is, hey, where can I send over the cancellation? And I'm looking for a reaction from the seller. It's the same technique as going for no, and it works very well. So you have to understand how these work. Now, let's move on to paragraph number 10, which I get a lot of questions on this, which I kind of find funny. This is where you put in all the terms that aren't fitted in this contract. And I love this as a wholesaler, as an ADHD guy, because remember, we always have a verbal agreement before we do the contract. So once we do the contract, if you told the seller, buyer to pay back taxes on property, that's what some of you guys write. For the most part, it'll usually protect you. But I've had an instance where I wrote this exact thing and they were behind 5 years. 5 years, guys, it was $30,000 and I ruined an entire deal on it. So how do we fix this? You simply change it to, you just kind of go here. You just got to be specific when you write these. And so what I'll put is limited to, I don't know, $3,000. She goes, I don't think it's more than $3,000. If they say that, I go, okay, we can pay up to $3,000. Hopefully it's less. So if it's like $2,200, you just save yourself $800. You see, you solve the seller's problem and you put it in here, and people don't know how to do these contracts. And I don't want to see a lawyer every time I have to add something in here. What about if I told the seller, I'm going to pay all the closing costs? Remember, if we go back, without killing your guys' eyes here, to number 2 on prorations, it just says they're going to divide everything up evenly like a traditional closing. Listen, most of my deals, I wind up picking up some of the bill, and I'll put on here buyer to pay title company closing fee. Closing fee, and then maybe I'll put in there title insurance. So I'm telling you guys, when you write these, you have to be very, very specific, because if you write it vague, it is a legal agreement, and God forbid a lawyer gets hold of it or you get an unfamiliar title company, it's going to be problematic. So when you write out your addendums, this is the addendum section. I'll put it in there. Remember, realtors add an entire separately document. Wholesalers just plug it right in here. And I make it simple and I go over it with them. But the more specific you are, the better off you are. If you just say, I'm paying the property taxes, well, if it goes back 5 years, you're on the hook for it. If you say, hey, I'm paying all closing costs, nobody knows what that means, including the title company. Are you paying the closing fee? Are you paying the title insurance? Who's paying the recording fees? So the more specific. Now, if I have a smoking deal, I say, listen, I'll just cover all your closing costs that come from the title company. It'll include your government fees. It's going to include your title insurance and all the closing fees, and I'll pay the property tax. But maybe I'm getting it 40, 50 cents on the dollar. Then that would be a time to go ahead and put it in there because you have such a low price. Remember, your seller remembers your verbal agreement much more than what you have in writing. The goal here is to always have them aligned to get the best deal possible. So now, last but not least, I know it's kind of boring. You do the, the seller's going to sign here. They're going to put 7524, and then they're going to print their name. And then you're going to come over here, 7524. You're going to do yours. Now, guys, if you're buying your personal name, it's no big deal. You can assign it just before. You can assign it to your LLC before you do an assignment of contract. That's why you want an assignable contract. But if you're buying under like Fortnite, I put it on here. It's important you put on behalf of Fortnite LLC, and then you put your title. Why is that important? Did you know if you do not put that claim or you sign for something personally, you might not have a fully executed contract and you might have created your own personal liability. So I prefer you guys buy these things in an LLC or whatever corporate structure you want to do. Remember, go see a CPA. I don't give accounting or legal advice, but if you're going to use a company, make sure you sign on behalf of the company and you put your title there. If not, you can be personally liable if there's ever a lawsuit because you signed your name personally. It's really important. And then just, you're going to print the name on there. So that is everything on the PSA contract. Honestly, you just keep them simple, guys. You guys complicate the crap out of them, and I want to keep them easy. So if you have contracts, put them in there. But the biggest thing I can tell you is you have to, when you're canceling due to your inspection period, and that's, remember, you're always canceling because the property didn't meet your expectations and you have that time built into it. But I don't want you canceling every time, guys. If you don't know how to write contracts, you're overpaying for contracts, go over to freewholesaling.com and figure it out. It's important that you notify them as soon as possible. So I'm going to do a phone call first. And my priority is first because I don't want my seller to get upset, and I still want to try to save the deal. Say, listen, I can't buy at that price because of XYZ, the AC, the roof. Would you consider so-and-so, or see if they'll negotiate with me? If not, where would you like me to send the notice of cancellation? And they're going to know, let's talk about it. That's a good time. But either way, I'm going to mail them a certified letter. It's going to cost you $7 or $8. Suck it up. This is the cost of business. And then I'm going to send an email, and I'm going to send a text, and I'm on the phone. That's how you get out of contracts correctly. If you find yourself doing it over and over, let's have a conversation, because you're probably doing wholesaling the wrong way. You guys got to write contracts that stick. Not all of them will stick. So the next phase is, Rick, I have a contract. What do I do? How do I sell it to my cash buyer? Let's walk through this. This is known as the assignment of contract. Now, if you're asking me, Rick, how the heck do I get these contracts? In the comment section, you'll see at the tippy top, I already posted a link to that. But if you're really curious, you want to learn how to go into detail on how to learn wholesaling, go over to freewholesaling.com. It is all in there, and we'll help you out with that. So, assignment of contract. This one gets a little bit more tricky, but the good thing is you can come back and refer to this video anytime, and we'll help you out. Now, if you read the top line, this agreement is blank, which is signer and assignee. You, the wholesaler, are the assignee. Okay? A lot of people mix these up. It's just like mortgager, mortgagee, assignor, assignee. The OR is you. You are the wholesaler. So this is going to be you. And XYZ will be your assignee. This is going to be your, actually, let's just put this in there so you guys don't mix this up. And we'll put in there as your cash buyer. Simple, right? Okay. So the next paragraph, you'll see assigner. Oh, you know what? I'm not sharing my screen. I apologize. There you go. So once again, there's you, the assigner, and then you have the assignee, it's the cash buyer. So we got that clarified. Trust me, guys, I've mixed these columns up. I've lost an entire deal because I put my name under assignee instead of assigner. The next one, assigner has entered into an agreement to purchase real estate with Jane Doe. So you look back to your original contract to get that information. The contract is attached hereby Exhibit A under the contract. Now, you're gonna have to put the same information you put on your PSA, and you're going to put the legal description in. You can put in the parcel ID, or you can just write in the information there. Once again, you can go to your official records. You can go to your property appraiser site. You can ask the seller for a copy of a deed, or you can use the tax ID number, aka the parcel ID number, which is usually a 9-digit code. Just guys, put stuff in there, and I'm always going to put the address on here, which is 123 USA Street, Stuart, Florida 34997. Okay, simple so far, easy. Don't lose me. This is the easy part. Let's go. Terms and conditions. Assigner assigns all rights he acquired under contract. Guys, this is the point of why we do wholesaling. Assigner, which is you, all rights acquired under the contract. So that means, pay attention to me, guys. Whatever you agreed with your seller, when you sell your assignment of contract, they just basically take your place. That's it. That's what you're doing. So if you understand that, you have to understand the next part here, which is the assignee accepts all terms and conditions of the contract. Assignee has reviewed the contract, which is attached to Exhibit A. Assignee fully understands the terms and the conditions of the contract and represents to the assigner that is willing to, able to close an underlying transaction. Now, I will tell you this. This is the trickiest part about you got to understand on how an assignment of contract works. Before you get into this point, you have already vetted your buyer. They've already looked at the property, and you've already agreed to a price. This is not a time for negotiations. Never, ever negotiate your assignment of contract without having a set of framework for your terms. So if you agreed, so we put it under contract for $150,000. If your goal is to make $10,000, which I want you to make more, but if your goal is to make 10 grand here, and that's what you can get, 150 plus 10, you're selling your contract to your cash buyer for what? $160,000. Stop obsessing what your assignment fee is. Just give them whole numbers. At this point, you've probably already vetted them, make sure they have proof of funds, and make sure they are like good buyers that understand how assignment of contract works. This is not the time to try to re-explain everything. This is the worst time to do it. You need eager people to move forward. So the biggest question I get is, Rick, when do I show the cash buyer the contract? And I'm telling you, once they've gone through the proof of funds, they've looked at the property, and they are at your title company, or you're meeting with them at a coffee shop or maybe like a mutual place, and they're handing you over a deposit or they're doing a wire. Once they do that and they're willing to sign this, then that's when we show the contract. I don't show it beforehand because I don't want them to look at the contract, get all the information, and then walk away and not commit. So you got to make sure they're 100% committed before you show this contract. Never, ever send your contracts over without some sort of firm commitment. The best commitment is when they leave the deposit. End of story. I like to meet them over the title company. I don't ever meet them there, but that's how I did it when I did it the first 7 years, and that's how I'm going to recommend you doing it. So they accept all the terms. So if you go to number 3, assigner will deliver to the assigner a cashier's check, money order, transfer, deposit in the amount of blank as the initial deposit in the transaction. Rick, what amount? You guys already know what I'm going to put in there. It's right here. $5,000. I don't care what market you're in. Unless you're selling $10,000 or $8,000 properties. But why do I do $5,000? Because people don't walk away from $5,000. Period. End of story. The bigger deposit you get on this contract, the less you have to babysit your cash buyers. It's important. Guys, don't take $500 and $1,000 deposits. People walk away from them all the time. $5,000 is the minimum. So once we understand that, we put in that. Now we go to section number 4. And this is where we're just, they go, Rick, I think you screwed up. You put it in here twice. I get this all the time. I didn't. In 4 and 5, it is a repetitive statement, so they understand fully what they're getting into. Now, remember, how much have we offered this property to our cash buyer for the contract? $160,000. Do you have $160,000? Yes. Do you want to buy it for $160,000? Yes. Do not complicate this. That's fine. Then what I'm going to do is basically my assignment fee is $10,000. You have to disclose it. There's no way around it. And then at closing, the assigner will receive $10,000. Why do I do this? Because you have to have full disclosure in these contracts. This right here, it's repetitive by nature. So if they ever say, I didn't know you did it, I go, dude, I did 2 columns back to back and I put it in writing. I can't be any clearer. And I gave it to the title company. So the next one is, now we go down to the math problem. And I don't know how people screw this up, but they do. So now you have a math problem. So the purchase of the underlying contract is $150,000. That's your previous contract. Your assignment fee is what? $10,000. I don't need a calculator here, guys. And we took a non-refundable deposit of $5,000. So basically that says total due at closing is just, you're going to take $5,000 from that $10,000, add the $5,000 to the $150,000, and that means they owe $155,000 at closing. Makes sense, right? I offered you my contract for $160,000. You left $5,000 in earnest money deposit, so you owe $150,000, $5,000 plus the closing cost. That's it, guys. Use this as your template. It's not complicated. I get a lot of questions on this, but most importantly is you've got to understand number 7. This is where most guru contracts do not write this in. And this takes a lot of experience. I've been burnt so many times on this. You got to understand this. It says right here, the important part is, assignee, which is your cash buyer, must close the underlying transaction on or before blank at 5 p.m. Time is of the essence. If the assigner will be harmed if assignee fails to time close, the assigner will select the closing agent. So we always select the closing agent, which you need to do the same thing on your purchase and sales agreement. I said it 1,000 times. But if we went back to our original contract, where did I put the date on there? We put it for October 5th. I'm going to make them close at least 2 weeks prior to that. So I'm going to put usually, well, I'm going to put on there by 8/30/24. And you're like, Rick, why are you doing that? Here's the reality, guys. If you do not put something in this section of your assignment of contract, guess what? They're all going to wait to close to the very last day. And guess what? If they don't close, what are you going to do? You're going to look really bad on your seller. You're not going to have time to replace your cash buyer to buy that contract, and the whole deal is going to fall apart. So never, ever do an assignment of contract without clause number 7. It is imperable. You want to have your cash buyer close at least 7 to 14 days before your closing date on your purchase and sales agreement. Why? Because it protects you in the event they fall apart. Think about this. You leave a $5,000 deposit and say you're a week before the close, and he goes, Rick, listen, you got to give me another month. Like, no can do. I go, listen, I'm going to keep your $5,000. We're going to move forward. You didn't follow the agreement. I go, you have till Friday. If you don't close by 5 o'clock on Friday, you leave me no choice. Monday comes around, nothing. He goes, no, just extend it. I keep the $5,000. Now I'm going to go back to the seller. So I got 5 days to put a cash buyer together. It's challenging. So the more time you can make that gap between your contract and what you do with the with your new assignee is going to protect yours. Now, what do I do if the guy asks out and like he can't close? Okay, we didn't get in this for $5,000, and you're gonna have to work to get that $5,000 back through your title company, but you'll win. But the reality is, I'm gonna go back to my seller and go, listen, I have to back it up like 2 weeks. I screwed something up. I tell you what, I'll go ahead and pick up your title insurance for the inconvenience. It's not going to be a quote. Oh, yeah. Okay, well, I'm going to send over some paperwork. We're going to get it done. Because usually when you have to extend the contract, you do have a 50-50. It's going to cost you more. You got to give them more for their inconvenience, because they can say no, and then what are you going to do? You're stuck. So you have to understand to make sure you have option number 7. Guys, it is so important to have that. So let's move on to the next page. This is one's only going to be 2 pages too. So I got to read clauses here. I apologize, but it gets boring, but it is important. So it says here on number 8, if assignee fails to close under the underlying transaction indicated in paragraph 7, which we just talked, they will forfeit their deposit, and all rights to the property under contract will automatically revert back to the assigner. What that says is they put up a non-refundable deposit, and sometimes you have to have your title company confirm that they're okay with that. That means you can take their deposit without their permission. Full disclosure, some of your title companies will make you sign a directive and have both parties sign it. My title company is fine with me having this in my signing the contract. Guys, my deposits, they're hard. If you do not come back, now I will tell you, I will give someone 6 months to use that deposit towards a future property if they didn't cause me any financial harm. I'm not an idiot, but I'm just telling you, this is how you keep their deposit. Without that language, it's nothing more than earnest money deposit. Earnest money deposit is neutral money that you have to agree to the terms on it. Once you agree to the terms, they leave the money. That money is hard. That money's either going to me one way or the other, either through the successful closing of the deal or you forfeiting the deposit. Now, if we move on to number 9, this gets interesting. If the assignee attempts to communicate with the sellers in any form, it will immediately terminate this agreement and forfeit their deposit liquid damages. Now, I'm going to be the first and foremost tell you, it'd be hard to enforce this one, but it's a reminder to your cash buyers is do not play with me because I will lock you down if you do it. They've been known to do this and they'll do it. Now, if you look on number 10, people always go, Rick, what happens if I get a property under contract and I can't figure out the title? We can't do it. And I enter into an assignment of contract. Number 10 is custom built for you. If you read it, a signer must deliver clear title at closing. If clear title cannot be given, then the assignment will be canceled. Deposit will be refunded to the assignee. So a lot of times your cash buyers will go, well, what if you can't clear that lien or something like that? Am I going to lose my $5,000? The answer is no. Like we're common sense. You can't take someone's $5,000 if you can't deliver a property, nor do you deserve that fee. So if they're worried about the integrity of it, in the event the non-refundable deposit would be given back is if I can't sell you this property. Now they got to give you reasonable time to do it, but this protects you. And a lot of you ask you like, how do I deal with it when they ask if I can't clear something? This is how you do it. Now, guys, let me see here. So on this one, now we're going to go back to 11. You go, Rick, you did it again. You got a typo. You reinforced it. No, I did this on purpose. So if you notice, this one and this one are going to be very similar. Assignee will not contact the seller identified in the contract. Assignee agrees to communicate solely with and through the assigner. So I basically broke it up in 2 different sections. And here's where I have these. I have the cash buyer. I have them initial that, and I have them initial that. Why? You try to go around me, I'm just going to take your money. So if that's your plan, it's going to be very expensive. Just so you know, most scam artists will not put up $5,000. And honestly, some of you get disappointed. She didn't leave me $5,000. I go, she was never going to do the deal. She was looking to burn you. These protections are put into your place. Now, moving on to number 12, which was one of my hard lessons, which I learned 3 or 4 times. And it says, a signer, which is you, may at any time before the closing renegotiate. I did the wrong one. Renegotiate. Let me highlight that. The underlying purchase price. So if I get the sellers to take a discount for one reason or the other, there can be a host of reasons. Maybe there's outstanding liens and you're working on getting them negotiated down. If I get a $10,000 reduction, that additional savings comes to me, the original assignor, the assignee doesn't get it. I got punched in the mouth for $30,000 once on a lien unnegotiated, and the guy goes, I bought your contract rights. Unless it's stated otherwise, it's my money. And he won. And I will never, ever let someone do that to me, and I don't want him to do it to you. 12, guys, I'm telling you, it's huge. All these ones I have highlighted are mistakes I've made in wholesaling, and I want to save you the aggravation of people trying to scam you because it's annoying as hell. So the next one is a real simple on 13, property sold as is. A signer makes no representation of the property condition. Why? We never lived in it. We don't know a whole lot about it, and we're not going to be liable. Once you buy it, it's yours. Buyer beware. There is no warranties. There's nothing. So unless you imply some other way, they've got to be willing to buy the property. We sell a lot of messed up properties. You have to have this clause in there because I don't want them to come back and blame you for anything. It says they've assumed to agree all risks related to the condition of the property. Why? Assignee must do their own due diligence. We do not tell them how to do it. Now, when it comes to doing due diligence, guys, I'm here to tell you, here's how wholesaling works. We are not realtors. We do not do full inspections. We do not do full inspections. What do I mean by that? Here, how you do it, you do a walkthrough. I tell you when you can go, how long you can be there, and you look around. And you make a decision. We got to the car, and you got like an hour to give me a decision. That's it. We don't bring in inspectors, and when your cash buyers surprise you, just make sure they understand that they're not going to look at that property. I do not let them treat it just like regular realtors do, and you have to understand that. So guys, the last part on this is going to be the signature. As usual, you're the assigner, and you're going to sign. You're going to sign this, and then you're going to put on behalf of Fortnight LLC, and then you put your title. If you were like president, you could put that there, and then you print it right there, and you put the date, which is, this will be 7, whatever it is, 24, and then your assignee is going to be your new one, and then they put all their information there. Guys, that's it. You have to start. Here, let me put me back on the screen some here. You have to start with a purchase and sales agreement. And then for you to transfer that purchase and sales agreement to a cash buyer, you have to have what we call an assignment of contract. They go hand in hand, and then they take over your position. I think the most challenging thing you guys struggle with is, I hear people go, Rick, do I actually have to show my seller, my cash buyer, the contract? You do, because guys, at the end of the day, we are selling the contract. Now, what I don't want you to do is email these contracts, deliver them before they've executed a deposit, they've signed the assignment of contract. And then I tell them, they go, well, what if I don't like the terms of the contract? I go, I tell you what, I usually give them 12 or 24 hours to look at it. But most people, unless you're hiding something, they're all in. They're like, yeah, okay, I get it. So if they have a tenant that's month to month, they're like, okay. Now, sometimes if you have a rental property, they will ask you for a copy of the lease. Sometimes a motivated seller landlord, especially a tired landlord, they don't even have it. And so we have to do what we call, the last part I'm going to explain to you is an estoppel. And estoppel is a fancy word I'm sure some attorney or law firm came up with. And then you go to the door and you ask the renter, how much are you paying for your lease per month? How long is the term of your lease? And is there a security deposit? And what are any terms we know about it? They put it in writing. It's basically like an affidavit. You give it to the title company, and then they review it with the seller to make sure that the renters, all their monies are accounted for. And so if you have a renter in there, I suggest you do the estoppel. Like, you don't need to hire an attorney to do it. They charge $550 to do it. It's ridiculous. And all they do is get a statement and they have them sign it. So it's real simple when they do it. But guys, this is going to be a summary of contracts, and these are the basics. Now, is this the only way you can do a contract? No, it's not. Is this the simplest way to do it? Absolutely 100%. It is very transparent. I can't give you a cleaner contract. And the intent is simply to buy their house, put it under contract, and then you have the ability to sell your contract. Guys, keep in mind, cash buyers are looking to buy deals. They're not stupid. Okay. So if you think you're going to pay slightly below retail and then ask for retail, you're literally wasting your time. That's not wholesaling. Go find a guru to teach you that. That sells courses. It does not make you rich. And if you do that, it's not going to work out. So the best way to learn how to do it, as I always tell you, is go over to freewholesaling.com, and you can go there, and I'll put it on the bottom here. You can learn how to do it, and it's easy. It's really easy, freewholesaling.com. So what I want to do is answer a few questions. I'm not sure I'm going to have time to do the lives because I got to do Flip with Rick Plus. We're going to be doing that right after it. If you want to know more about Flip with Rick Plus, make sure that just go over to flipwithrickplus.com. It's just more time to spend with me and Zach. It's not a requirement. I'll do deals with you with or without it, but like my best partners are inside of Flip with Rick Plus. But you all are amazing, and everybody's got to start somewhere. So check that out. And we also have the live event coming up. I want to say it's October 23rd, 24th, but we're waiting to get some paperwork back. But it's going to be in Orlando. So if you want to come out, meet me and Zach in person, we have a blast there, and it's a lot of fun. So let's jump over and do some questions. I had a question. So those of you looking for the Discord, I keep seeing comments about that. You can check it out. I believe Zach's going live tonight. I might jump in there with him. God only knows. I don't know how to navigate in it real well, but that is zachdiscord.com. I let him run that because it's hard for me to even turn it on sometimes. So, but let's jump through the. So Jillian says, "Hey, listen, the deal or the buyer first," and everyone's got a different way to do this. I'm going to be honest with you. I got a deal before I got a buyer when I started, but I got lucky because I did find a cash buyer off of a sign I put out in the yard. And it wound up being one of my first cash buyers who bought my first 20 properties. I got lucky, but I struggled after that. And I already told you guys a story. I went out and JV'd with a lot of other wholesalers to get through because I didn't know how to sell properties. So it doesn't matter. Ideally, you work on them both at the same time. That's going to be the best way to do it. But if you get a deal before you get a cash buyer, consider doing a JV with me or Zach or somebody in our community, because I'd rather you make some money than no money, and it'll also give you the confidence and the education to do more deals. So yes, guys, this is recorded. It'll be there. Remember, this is day 5 of our 30-day challenge. Every day, me and Zach put out a video, and we give you step by step of like what to do right now in 2024. And I'm here to tell you guys right now, I would love to hear some feedbacks on your markets. It's getting soft in Florida, man. Like there's the inventory stacking, interest rates are not going backwards, and people are struggling to get mortgage, and fix and flippers are really they're really pulling back on what they buy right now. But I think this is perfect for a great opportunity for us, because now realtors need help. Properties are sitting on the market. I think it's kind of, I'm not going to say it's funny, but like, guys, we do need prices to come down a little bit. They can't just keep going up like 10, 12% a year. It's insanity. But I'm hearing from, I know New York's having a lot of problems. Florida's already has some struggles. So if you guys want to put in the comments of stuff you guys see going on in your markets, it would be great. But keep your eyes open, because usually the doldrums of summer, we got elections coming up towards the end of this year. It's going to get real interesting in wholesaling. And here's the key, guys. Always be in wholesaling. I've done this 21 years. If you think you're going through a roller coaster ride now, you should have been with me in 2008. We had the markets, like I made so much money in a short amount of time. And then the market dropped out. I got caught with properties that I wasn't wholesaling, that basically cleaned my clock. And then I had to rebuild and all the way up for the next 10 years, figure out how to do wholesaling. And I figured out if you just did the fundamentals, you did very well. You need to know if your market's up or down, which way it's going, but you just pivot on buyers and sellers on it. That's all you do. So the only people who get screwed in wholesaling are the ones who quit. And anyone who says they got killed in wholesaling, especially in 2020, 21, 22, it means you didn't know how to do wholesaling. You can't get killed in wholesaling because you minimize your risk and you maximize your reward. Worst case scenario, you just don't make any money. That's the whole idea of it. But if you took a loss, it means you took a gamble, which means you're a speculator. And I don't teach that. The only time I've ever got killed in real estate is when I speculated. I did fix and flips, or I bought properties and hoped somebody would pay me more. Those days are over. I do that, but I can afford to do it. As a beginner wholesaler, that is the last thing you want to do. So, Leah says, what about mentioning who's paying the closing costs for the seller and buyer? Should that be bulleted point in your contract? So here's what I do. I usually specify that in the special addendum part. So if I pull up my contract here, Let me go back to the original contract. It's going to be right here in this section where it says addendum with my terrible, terrible handwriting. I know I should have been a doctor. That's where I spell it out. And the key here, Leah, is be specific. Put limits on it, because if it's a big number, you're going to get stuck. And I don't want that to happen to you. So good question. Awesome question. And let's see what else I got here. I'm not doing that. Let's see. This is not. So he asked what type of paper to use for the envelopes. They just it's just paper. Like I don't even like. I'm not a paper expert. I just go and get like Staples paper or have a ream delivered to you, and just simple paper. I just make it white, 8.5 by 11, and the envelope just a simple regular envelope. I don't even know what, like, I guess a number 9 envelope or whatever they call it. I wouldn't worry about it. Let me see what else I have here. So anyway, the reason why we don't change the order of the contract, because there is a hierarchy in the law, and I'm not here to get into it. So I don't care how it works. I know my contract's been tested multiple times, and by far than just me. So I don't like to reinvent the wheel. But if you want to pay a lawyer and rearrange it, you can check it out. It makes sense to what you're saying. I'm not opposed to it. I'm just not a lawyer, and I don't get into legalities. My specialty is in finding the motivated sellers and helping you guys out and closing my deals as well. But not a bad idea either. I don't disagree with it. So awesome. So those of you in the Discord, I think it's really cool. If you guys haven't checked it out, go over to zachdiscord.com. We hang out, we chat in there. I figured out how to turn it on. I actually had it on my phone, and you guys are sending me messages, which is pretty cool. I'm just figuring out how to message and work with it. Those of you asking about Flip with Rick, that is a community me and Zach created that you can get in it for free by sending us a JV deal. Go out and use the skill sets we teach you at freewholesaling.com, and we'll show you how to partner up with us. And you can, every deal you send, you get 1 year free with it. A lot of people just want to skip the line. I think they pay like $100, and we spend more time with them to get deals, and they ask great questions, and we work together. Remember, it's a community. It's not a one-on-one. I don't do one-on-one. Anyone who does one-on-one, just beware. Like, it doesn't make sense. Like people who do 15 minutes or like hour phone calls, they put a price on their time. To me, I like to do deals, and that's what I do best at. But like, if I did one-on-one, I literally wouldn't have enough time in the day for the amount of people I help out, because I want to help out as many people as possible. Nobody helps out as many people in wholesaling as me and Zach do. And if anybody wants to claim or argue that dispute, just show me the proof, because I think we're up around 9,000, 10,000 testimonials I've never even asked for. Most of the gurus will tell you, make sure you extract that testimonial. You guys just give it out. You do it in the Wholesaling for Houses for Real, which I believe this month we're getting ready to be the largest wholesaling group on Facebook on planet Earth, which I think is really cool. So check it out there, and make sure you go over to Zach Discord. And guys, if you have any other questions on contracts, just leave a message on here. I will try to answer it in the comment section. And guys, listen, wholesaling is 100% legal. Stop buying into all the hype. People tell you it's banned and stuff like this. There will always be a way to put a property on a contract, even if one day they decided to outlaw everything, which is not going to happen. And I need you, the people. You guys already decided this on July 4th. And if you guys look back at our founding fathers, I want to give you an amazing fact. You know that James James Madison or Madison Monroe? I'm mixing this up. He was only 18 years old, and he's one of the persons that was part of creating the Constitution, and is one of the reasons why you're in this great country and you have the freedoms you do. And most of the people that participated in creating this beautiful country were in their early 20s. Can I be very clear? I think the oldest person was 30 years old that wrote on it. Remember, a different time back then, most people didn't live past 40. But these people signed documents knowing that if they got caught, it was penalty, that the ultimate penalty of their life. And I'm here to tell you, I'm always going to stand up and represent wholesaling and protect you guys because I love this business. It gives us amazing freedom. And if someone ever tries to take away it, we got to take the power back. We have to stand up. So here's how you guys stand up. Read your state laws and stop accepting news from the media because most people are going to spin you and they usually have a reason for doing it. So if they're that powerful that we can form a country at 18 years old, 18 in their early 20s, imagine how much power you have to go out and just talk, find motivated tellers and help walk them through their situation to help them out of a bad situation, help you make a ton of money. Remember, it's not the money you're chasing. The money gets you the freedom of your time to spend time with your loved ones on the 4th and everything you want to do. Shoot off fireworks, go play football, go get in the pool. It's hot as hell out there right now. Guys, it's up to you. It's up to us. We want to do it. I love this community. Guys, it's important. Understand your purchase and sales agreement and then follow up with the assignment of contract. This video is recorded. This is day 5 of our 30-day wholesaling challenge. We're in 2024. This is an amazing opportunity, guys. Go out there and get it. The time is right. The market's getting soft. I think you're going to have wonderful opportunities, but it doesn't matter. Wholesalers just show up every day. If you have a question, leave a message. I'll answer it. I'll see you guys real soon. If you're jumping on Flip with Rick, I will see you on the other side. And guys, have a good one. Enjoy. Be safe out there. Have a great day. Let's go get